So you're thinking about joining the National Guard, or maybe you've already signed up and you're about to head to basic training. And there's this nagging question in the back of your mind. What happens to my job? Can my boss fire me for missing work every month for drill weekends? What about those 2 weeks of annual training? And here's the big one. Does my employer have to pay me while I'm gone, or am I just out of that income? These are legitimate questions, and if you don't know the answers, you could end up in a really bad situation. The good news is that there's a federal law specifically designed to protect service members' civilian employment. It's called USERRA, the Uniformed Services Employment and Reemployment Rights Act. And by the end of this video, you're going to understand exactly what your employer has to do, what they don't have to do, and how to protect yourself if they try to violate your rights. Let's dive in. First, let's talk about what USERRA actually is, because this is the foundation of everything. USERRA is a federal law passed in 1994 to protect the employment rights of people who serve in the military, including the National Guard and Reserves. The basic idea is this: if you're serving your country, your civilian employer can't punish you for it. They can't fire you, they can't demote you, they can't deny you promotions or benefits. They can't discriminate against you because of your military service. USERRA applies to almost all employers in the United States, public and private, regardless of their size. Whether you work for a massive corporation, a small business with 5 employees, or a government agency, USERRA protects you. And it covers all types of military service, including active duty for training, initial active duty training like basic training, inactive duty training like drill weekends, full-time National Guard duty, and funeral honors duty. Basically, if you're doing anything military related, USERRA has your back. Now here's what USERRA requires from your employer. Number 1, they have to give you time off for military service. This is non-negotiable. You're not asking permission to go to drill or annual training. You're notifying them that you have a military obligation and you will not be available for work. The employer cannot deny you that time off, and they cannot retaliate against you for taking it. It doesn't matter if it's inconvenient for them. It doesn't matter if you're their best employee and they really need you that weekend. It doesn't matter if they're short-staffed. Your military obligation comes first, and the law protects your right to fulfill it. Number 2, your employer has to re-employ you when you return from military service, as long as you meet certain conditions. Those conditions are pretty straightforward. You have to give your employer advance notice of your military service as soon as practical, unless impossible or unreasonable like emergency call-up. You can't be gone for more than 5 years cumulatively from that employer, with some exceptions that we'll cover. You have to return to work or apply for reemployment in a timely manner, which depends on how long you were gone. And you have to have been released from military service under honorable conditions. If you meet those requirements, your employer has to take you back. And not only that, they have to put you in the position that you would have been if you never left. This is what's called the escalator principle. That means if you would have gotten a raise or a promotion while you were gone, you get that raise or promotion when you come back. If your seniority would have increased, it increases. You pick up where you left off, not where you were when you left. Number 3, your employer cannot discriminate against you because of your military service. They can't refuse to hire you because you're in the Guard. They can't fire you because you have drill obligations. They can't pass you over for promotions because you occasionally miss work for military duty. And they can't create a hostile work environment or treat you differently because of your service. If your employer is doing any of these things, they're violating federal law, and you have legal recourse. All right, so those are the big picture protections. Now let's get into the nitty-gritty details, because this is where things get more complicated and where a lot of confusion happens. Let's start with the question everyone wants answered. Does my employer have to pay me when I'm on military duty? And the answer is no, they don't. At least not under federal law. USERRA does not require your employer to pay you for time you're away on military duty. When you're at drill or annual training, you're getting paid by the military. That's your income for those days. Your civilian employer is not legally obligated to supplement that or pay you on top of that. Now, that's federal law. Some states have their own laws that provide additional protections. For example, paid leave in Illinois or California. And some employers voluntarily offer military pay differential programs where they make up the difference between your military pay and your civilian pay. But those are bonuses, not requirements. The baseline is that your employer does not have to pay you while you're in uniform. Let's break down how this works in practice, because it depends on whether you're hourly or salaried, and that's a critical distinction. If you're an hourly employee, this is pretty straightforward. You get paid for the hours you work. If you're at drill on Saturday and Sunday, you're not working your civilian job those days, so you don't get paid by your civilian employer for those days. You're getting paid by the military instead. Same thing for your 2 weeks of annual training. You're not working for your employer, so they're not paying you. You're on military orders and the military is paying you. Now, the military pay rate is probably different from your civilian hourly rate, so you need to factor that into your budget. If you're making $20 an hour at your civilian job, but only getting the equivalent of $12 an hour from the military for drill, you're taking a pay cut those weekends. That's just the reality. If you're a salaried employee, it gets a little more interesting. Salaried employees typically get paid the same amount every pay period, regardless of how many hours they actually work. So the question becomes, if you miss work for drill, does your employer have to pay you your full salary for that pay period? And again, the answer under USERRA is no, they don't have to. However, many employers choose to continue paying their salaried employees their regular salary even when they're on military duty, because it's administratively easier and because salaried positions are usually seen as compensating for overall performance rather than specific hours worked. But this is an employer policy decision, not a legal requirement. Some employers will pay you your full salary and let you keep your military pay on top of it. Some will pay you your salary but require you to turn over your military pay to them, which is frankly kind of a crummy policy, but it's legal. And some won't pay you at all while you're on military duty. It varies widely. Here's where things get tricky with salaried employees, and it's something a lot of people don't understand. Exempt versus non-exempt status under the Fair Labor Standards Act. If you're a salaried exempt employee, your employer generally can't dock your pay for partial week absences. So if you miss Friday for a drill weekend, they might not be able to legally reduce your salary for that week, depending on the specific circumstances. But if you're gone for a full week, like during annual training, they can potentially not pay you for that week. The interaction between USERRA and FLSA salary basis rules is complex, and honestly, if you're in the situation, you should talk to an employment attorney or contact the Department of Labor's USERRA office for some guidance. Now let's talk about notification requirements, because this is critical. You can't just not show up to work and then claim USERRA protection after that. You have to give your employer advance notice of your military service as soon as it's practical. The law says the notice should be given as far in advance as possible, and it can be written or verbal from you or your commanding officer. For drill weekends, you should be giving your employer a training schedule at the beginning of the year showing all your drill dates. For annual training, you should notify them as soon as you know the dates, ideally several months in advance. If you get activated for a deployment or emergency orders, you give them notice as soon as you're able. The key is that you're being proactive and communicating. Most USERRA problems happen because of poor communication. Your employer can't accommodate your military service if they don't know about it. Let's talk about some real-world scenarios to make this more concrete. Scenario 1. You work retail. You're hourly, making $15 an hour. You have drill 1 weekend a month, and you notify your manager at the beginning of the year with your drill schedule. Your manager says, "That's fine, just make sure you find someone to cover your shifts." Stop right there. That's not how this works. Your manager cannot require you to find shift coverage for military duty. That's the manager's job. You notify them of your absence, and they figure out how to cover it. You're protected under USERRA. You don't work those drill weekends. You don't get paid by your civilian employer for those days, but you get your military pay, and your job is protected. Scenario 2. You're a salaried project manager making $60,000 a year. You have 2 weeks of annual training coming up. You notify your boss 3 months in advance. Your company has a policy where they continue to pay your full salary during military duty, and you get to keep your military pay as well. Lucky you. That's a great employer. Not all companies do this, but when they do, it's a huge benefit. You go to annual training, you get your military pay from the Guard, you get your regular salary from your employer, and you come back to work like nothing happened. Scenario 3. You're an hourly warehouse worker making $18 an hour. Your employer is a small business with 10 employees. You get activated for a 6-month deployment. You notify your employer immediately. Your employer says, "We can't hold your position for 6 months. We need to hire someone to replace you." Too bad for your employer, because that's exactly what USERRA requires them to do. They can hire someone temporarily to fill in while you're gone, but they have to give you your job back when you return. They can't use your deployment as an excuse to get rid of you. You deploy, you serve, and when you come back, you apply for reemployment within the required time frame, and your employer has to take you back. Let's talk about that 5-year rule I mentioned earlier, because it's important, but it also frequently is misunderstood. USERRA protects your reemployment rights as long as your cumulative military service with that employer doesn't exceed 5 years. So if you've been working for the same company for 10 years, and over those 10 years you've done 1 weekend a month, 2 weeks a year of guard duty, plus maybe a 6-month deployment, and it all adds up to less than 5 years total, you're protected. If you go over 5 years, you could lose your USERRA protections with that employer. However, there are exceptions. Drill weekends and annual training generally don't count towards the 5-year limit, as long as they're required training. Involuntary activations like mobilizations ordered by the president don't count. Service to fulfill an initial military service obligation doesn't count. So in practice, most Guard and Reserve members never come close to hitting the 5-year limit. But it's something to be aware of, especially if you're on extended active duty orders. Now let's talk about what happens when you return from military service, because there are specific rules about how quickly you need to report back to work. If your military service was less than 31 days, like a drill weekend, you have to report back to work at the beginning of your next regularly scheduled shift after you've had 8 hours of rest following your return home. So if drill ends Sunday evening at 6 p.m. and you have an 8-hour shift starting Monday morning at 8 a.m., you don't have to be there Monday because you haven't had 8 hours of rest, but you need to be there for your next shift after that. If your service was 31 to 180 days, like maybe an extended training period, you have to apply for reemployment within 14 days after completing service. If it was more than 180 days, like a deployment, you have 90 days to apply for reemployment. Miss those deadlines, and you could lose your USERRA protections. What about benefits like health insurance, retirement contributions, and vacation time? USERRA has you covered there too. Your employer has to continue your health coverage while you're on military duty for up to 24 months. Though you might have to pay your portion of the premium and sometimes a bit more. When you return, your health coverage picks back up like you never left. For retirement plans, if your employer has a 401k with matching contributions, your employer has to make up any matching contributions they would have made if you'd been working there during your military service. You get credit for that time. Vacation and sick leave are a little bit more complicated and depend on your employer's policies. But generally, your employer can't treat military leave less favorably than they treat other types of leave. Let's talk about discrimination and retaliation, because this is where USERRA's teeth really show. It's illegal for your employer to discriminate against you because of your military service. That means they can't refuse to hire you because you're in the Guard. They can't fire you because you have military obligations. They can't deny you promotions or raises because you occasionally miss work for a drill. They can't create a hostile work environment where you're constantly being hassled or given a hard time about your service. If you're experiencing any of this, document everything. Keep records of conversations, emails, performance reviews, anything that shows a pattern of discrimination or retaliation. Because if you need to file a complaint, you're going to need to have evidence. What do you do if your employer violates your USERRA rights? First, try to resolve it internally. Talk to your supervisor, HR, or your company's leadership. Many USERRA violations happen because of ignorance, not malice. Your employer might not understand the law, or they might have policies that inadvertently conflict with USERRA. Sometimes educating them about the law is enough to fix the problem. If that doesn't work, you can file a complaint with the Department of Labor's Veterans Employment and Training Service, also known as VETS. They have a USERRA division that investigates complaints and tries to mediate disputes between service members and employers. If VETS can't resolve it, they can refer your case to the Department of Justice or the Office of Special Counsel, depending on whether your employer is private or governmental. And if you want to go the legal route directly, you can hire a private attorney and sue your employer for USERRA violations. If you win, your employer could be on the hook for back pay, lost benefits, liquidated damages if the violation was willful, and your attorney's fees. There's also a great organization called ESGR, which stands for Employer Support of the Guard and Reserve. It's a Department of Defense program that promotes cooperation and understanding between reserve component members and their civilian employers. If you're having issues with your employer, ESGR can provide mediation services. They'll reach out to your employer, explain USERRA, and try to work out a solution. It's free, it's informal, and it often works. Plus, ESGR gives out awards to employers who go above and beyond in supporting their Guard and Reserve employees. So they're all about fostering positive relationships. Let's address some common misconceptions because there's a lot of bad information out there. Misconception number 1. My employer has to pay me for drill weekends. No, they don't, unless state law or company policy says otherwise. Misconception number 2. I can get fired during my probationary period because I'm in the Guard. No, you can't. USERRA protections apply from day 1 of employment, even if you're in a probationary period. Misconception number 3. My employer can make me use vacation time for drill. No, they can't. Military duty is separate from vacation time. Your employer can't force you to use paid time off for military obligations. Misconception number 4. If I get deployed, my employer can hire someone permanent to replace me. No, they can't. They can hire someone temporarily, but they have to give you your job back when you return. Misconception number 5. USERRA only protects active duty deployments, not drill weekends. Wrong. USERRA protects all forms of military service, including drill. Here's a real-world example that illustrates how USERRA works. A few years ago, there was a case involving a reserve officer who was a police sergeant in a major city. He got mobilized for a deployment to Afghanistan. While he was deployed, the police department promoted several officers to lieutenant. Under normal circumstances, he would have been eligible for those promotions based on his seniority and performance. When he returned from deployment, he applied for reemployment and asked to be considered for the lieutenant promotion retroactively. The police department said no, arguing that he wasn't working during the promotion period, so he couldn't be considered. He filed a USERRA complaint. The case went through mediation and ultimately the courts. The decision was clear. USERRA requires that the service member be placed in the position they would have been if they had never left. That included being considered for promotions. The officer was retroactively promoted to lieutenant, given back pay, and awarded attorney's fees. That's USERRA in action. Here's another example. A National Guard member worked for a retail chain as an assistant store manager. She was salaried, making about $45,000 a year. She had drill 1 weekend a month, and her district manager started giving her bad performance reviews, citing her unreliability and lack of commitment because she missed work for drill. She was eventually demoted to an hourly sales associate position, and she filed a USERRA complaint with vets. After an investigation, vets determined that the company had violated USERRA by discriminating against her based on her military service. The company was forced to reinstate her to the assistant manager position, give her back pay for the lost wages, and undergo USERRA training for all managers. That's how USERRA protects you from discrimination. Now let's talk about the practical side of balancing a civilian job and Guard service. Yes, you have legal protections, but that doesn't mean it's always easy. Being in the Guard requires good communication, planning, and sometimes compromise. Give your employer as much advance notice as possible. Keep them updated if your training schedule changes. Be proactive about making sure your work responsibilities are covered while you're gone. If you're in a position where your absence creates a real burden on your team, acknowledge that and do what you can to minimize the impact. The goal is to be a good employee and a good soldier or airman. Most employers are supportive of military service, especially if you're professional and communicative about it. Also, consider your career trajectory and how the Guard service fits into it. Some jobs and industries are more compatible with Guard service than others. If you're in a field where being gone 1 weekend a month and 2 weeks a year is relatively disruptive, you might face more challenges, even though you're legally protected. On the flip side, some employers actively seek out Guard and Reserve members because they value the leadership, the discipline, and the skills the military service develops. And some industries like federal government jobs, law enforcement, and firefighting have strong cultures of supporting military service and often have policies that go beyond what USERRA requires. If you're thinking about joining the Guard and you're worried about your job, talk to your employer before you sign up. Be honest about what the commitment involves. Gauge their reaction. If they're supportive, great. If they seem hesitant or hostile, that's a red flag. And you might want to consider whether that's the right employer for you long term. USERRA will protect you legally, but if you're going to be fighting with your employer constantly, that's going to make your life miserable. Here's the bottom line. If you're in the National Guard or Reserves, or you're thinking about joining, you need to understand USERRA. Your employer has to give you time off for military duty. They have to give you your job back when you return, and they can't discriminate you because of your service. They do not have to pay you while you're gone unless state law or company policy requires it. Whether you're hourly or salary, the principle is the same. You're legally protected. But you need to communicate, document, and know your rights. If your employer violates you, Sarah, you have options, from internal resolution to filing complaints with vets to hiring a lawyer. And organizations like ESGR are there to help. Serving in the Guard is a commitment, and balancing it with a civilian career requires effort. But you're not doing it alone. The law is on your side, and there are resources available to help you navigate any challenges. Because whether you're a weekend warrior or a full-time citizen soldier, you deserve to know how to protect your civilian career while serving your country. Thanks for watching, and I'll see you in the next one.